take part in our session today. This is our first session since the summer break. First, I want to go over some housekeeping. On our website is the PowerPoint and a not completely edited but abridged chapter from a book that's being worked on now, and that's the chapter on TOLI Liability. The book we have that we're working on now, we've got about 16 chapters in the book. About 12 of them are pretty much done. We're hoping to get this book out in the beginning of 2018. So if you do not have the information, you can go to our website and pick that up. It's also, I think, on the screen here, or the information you received today. But you can go to the website, and at the website also you can get the forms for the CE for both CFP and CTFA. Also, I'd like to note that you can ask questions. Typically, the question is pertinent and something that we should be dealing with along the way. We will. If not, we will save it to the end. But you can ask questions, and we do encourage that if you have a question. For this particular session, I just would like to note I am not an attorney. I'm reading these cases, looking at these cases, and I'm interpreting them, but I do deal with these issues daily, and so it's really from the perspective of somebody dealing with life insurance and managing life insurance. Before we get started, I wanted to note two things. We've written a lot in the past about the COI increases and the lawsuits around the COI increases. Two bits of information that just came to me in the last 24 hours, the first of which is there was a lawsuit against Lincoln National that was consolidated. We wrote about it in our blog. That lawsuit is going to move forward. The second item is that we wrote about an interesting case last week or the week before, an interesting case in Los Angeles where a church group who had purchased 2,400 policies, actually funded by an investor, was suing Transamerica for a cost of insurance increase. There's a backstory to that case. You can read about it on our blog. It was also written about in the Wall Street Journal. But the bottom line is that case was in court last week, and actually yesterday it was found in favor of the church, and Transamerica will have to pay $5.7 million from the information that I've received to the church parishioners. So those are two items there that we'll be talking about or writing about in the next few days. I just wanted to let you know. Before we get started, let's take a look at our next two sessions, our next two webinar sessions. The first on artificial intelligence. Elon Musk says it will cause big issues. Vladimir Putin says whoever leads in this area is going to be the ruler of the world. Artificial intelligence, what is it, and how will it affect the world we live in, specifically the banking and finance business? We at ITM 21st really have a robust IT group. Many of you probably don't know this, but of our 100+ employees, 15 or so are focused solely on IT, security, and software development. And yes, even we are dealing with artificial intelligence in our own way. We believe it'll be very important over the next decade, and also believe that it will affect your lives dramatically. So our session will talk about what artificial intelligence is, and more importantly, what it will mean for all of us in the banking and finance sector. One note, while we have 1 hour of CE for CTFA, the CFP board would not approve this course. I went back and forth with them, but the board finally sent an email to me that said the course is more relevant to CFP's own business than knowledge, skills, and abilities needed to provide personal financial planning. Nevertheless, it's going to be a great session. Will affect you whether you are a CFP, a CTFA, or an advisor of any sort. So it'll be a great session. We also decided to run a basic course in the fall session on life insurance because after speaking with a number of trustees and trust administrators, we quite frankly felt it was needed. This course is really going to take a look at life insurance policy types and explain them in a practical way for those who are not life insurance experts. And the key here is that we're going to explain them in a way that focuses in on characteristics like flexibility, death benefit guarantees, etc., things that you as trustees need to grasp if you're managing life insurance, but you don't completely understand the inner workings of a policy. We believe that you do not need to be a complete expert to understand the issues around the policies in your trust, but you have to have a basic understanding, and that will be our goal in this course. And I hope if you deal with life insurance and you're not an expert or a CLU, that you'll attend the course. And even if you are an expert or even if you are a CLU, I think you'll get something out of it. The last thing before we get to our agenda, we've sent out a customer survey. So any of our customers who are on the line, I know you're all busy, but if you could help us out, we would appreciate it. If you get an email with our customer survey, we really appreciate it if you would respond. We try to be partners with our clients, and we want to improve in any way. And this is a great way for us to find out how we're doing and how we can do better. For this survey, we're giving away a few Amazon gift cards in the drawing for those who respond. Your answers are anonymous, but we do know who responded. We just don't know what you said. So if you could help us out, that would be great. For today's agenda, we want to accomplish really three things. We want you to get an understanding of what these TOLI cases tell us for those of us who are managing life insurance. And we want to relate the cases to real life, to what's really going on in the trust-owned life insurance world. And we want to show you how to avoid the issues that these trustees, these entities came up against that forced them into court. The important thing here is that we're trying to mitigate liability for trustees, and there's a reason for this. I mean, why should we be worrying about this? Well, in one case we're reviewing today, the judge wrote that a violation by a trustee of a duty required by law, whether willful, fraudulent, or resulting from neglect, is a breach of trust, and the trustee is liable for any damages caused by the breach. And the important thing here is that it does not matter whether the violation occurred because you are neglectful or because you willfully attempted to create a breach, you will be liable. So, as they say, ignorance of the law is no excuse. There are a number of expectations, actually more like requirements for trustees, and we're going to see these as we walk through the cases we're going to review today. First of all, you have to prudently invest the asset in the trust, and you have to follow the specific terms as laid out in the trust agreement, and we'll see where that can help you as a trustee, but we're also going to see where following the terms did not save one trustee, and I'll show you the reasons why. You must refrain from using the trust property from your benefit as trustee, and one case speaks to self-dealing with an interesting outcome. You must always act impartially and administer assets in the best interest of the beneficiaries. In a couple of cases, we'll touch on this, and one will certainly touch on it directly. And you have to avoid conflicts of interest, and you also have to act impartially and administer assets in the best interest of the beneficiaries. We're going to touch on this, and we're going to touch on the fact that you have to avoid conflicts of interest. And there'll be one case where that's especially telling. So let's take a look at the first case we're going to review today. And that's the Cochran case. And this is one that's been talked about a lot. And it's one that many pundits out there believe is one where maybe the court set a very low bar. The bank was successor trustee to a trust that held 3 life insurance policies and an annuity. And the first thing I want to note is that the bank became trustee because the former trustee relinquished control over the trust, at least partly because of the grantor's insistence in having himself and other third parties getting involved in decisions. And this is a red flag, and it was the first red flag in this case, in my opinion. Around the time KeyBank took over, the agent for the grantor recommended that the bank exchange the existing policies for 2 variable life policies, which, as you know, are tied to the equity market. That exchange was approved in 1999, and then 9/11 hit in 2001, and the equity markets tanked. After the market tanked, the agent came back with another idea. Exchange the variable policies for a guaranteed universal life policy, which has no investment risk. And the bank went ahead and made the replacement. So why did the bank do this? Well, For one reason, the grantor's finances took a downturn and he was not going to be able to fund these policies anymore. There was going to be no more gifting to the trust, which is something that we have to deal with more and more, it seems, these days. You know, with the changes in the estate tax laws, more grantors are stopping their gifting and they believe they do not need the asset anymore. But of course, as trustee, we still have the responsibility to maximize the asset and to prudently invest for the beneficiary. Anyway, in this case, the bank retained an outside consultant to audit the VUL policies. And at the time, the insured was 52 years old. So, assuming no more premium and an 8% return, the advisor said the existing VUL policies would run until the insured was approximately 70 years old. And if the returns were zero, they calculated the policies would run to only ages 58 or 60. So only 6 to 18 more years would these policies run. So it was clear that with no additional funding, these policies would not make it until the grantor's probable life expectancy. And remember, the grantor at this point in time was insurable, so a 6 to 18 year life expectancy was very, very short relative to reasonable expectations. So the bank reached out to this outside vendor who had no skin in the game. In other words, they were not going to make a commission on the transaction. The agent who brought the idea to the bank, and remember, this was not the bank's idea, it was the grantor's agent's idea. He only really looked at one policy type and one carrier as the option. So could or should the bank have looked at more? Well, the outside vendor recommended KeyBank move forward with the proposed John Hancock coverage as long as the client was comfortable with the reduction in death benefit. And so I would interject here, who's the client? The real client is not the grantor, but the beneficiary, right? Nevertheless, KeyBank did move forward, placing the GUL policy in force in June of 2003. And with the cash from the existing policies and no more, it purchased just over $2.5 million in death benefit. Remember, the original policies had $8 million in coverage, but they were not going to last. This policy would last, but would provide much less coverage. So, would you as trustee have done this replacement? It's a good question. The bank did, and the grantor died the next year, very prematurely. And the beneficiaries filed suit. They alleged that the bank breached their fiduciary duties as trustee because they delegated their decision-making functions. Remember, they allowed the agent to bring the idea to them and then went along pretty much with exactly what the agent said to do. The beneficiaries said the bank disregarded the outside vendor's advice, which seemed to be a stretch, but they also said the bank failed to investigate other options for the transaction and only looked at retaining the existing VUL policies or exchanging them, which pretty much is what happened. They only looked at one policy type to exchange it to as one carrier. And they said the bank breached their duty of loyalty to the beneficiaries by essentially acting in cahoots with the grantor and his agent. So the beneficiaries charged that the bank imprudently and improperly delegated certain decision-making functions to the grantor insured and his agent, since they moved ahead with a replacement that the agent had initiated. The court did not see it that way and disagreed with the beneficiaries. And the fact that the bank had reached out to a fee-based outside vendor played into the court's decision. The agent did initiate the discussion of the transaction, but the bank had looked to an outside independent entity with no policy to sell or any other financial stake to take a look at the existing policies and the replacement option and provide their thoughts. And the court found in favor of the bank. The crucial point being that the outside vendor was not going to gain anything by allowing the transaction. If commissions were involved, then maybe the outside vendor's recommendations might have been somewhat tainted, but there was, as the court says, no financial stake here, which was an important consideration. So the court found that the bank did not delegate any investment or other duties to the writing agent. There are 2 points, 2 questions here that I think are relevant and important. The first is, how much influence does the grantor have over you and your decisions? We'll also see this in a later case. The grantor cannot sway your decision. Decisions must be for the best interest of the beneficiary. But we have run across situations where a bank might be tempted to be swayed because, for example, a grantor has a large loan with the bank or maybe millions of dollars under management at the bank or the trust company. And this does happen. It's human nature because the relationship that you have is with the grantor. But obviously, that cannot affect the decision-making process. The second question is a bit harder. Do you really understand the life insurance policies in a replacement? Do you understand the new policy and the existing policy and the options? Do you understand how those options act out and how you can make a prudent decision, a prudent choice that will keep you out of court, which is the key here? So I wanted to point out 2 situations we ran into that can show you how you can get into trouble. The first was a situation similar to this case in that a grantor had a strong relationship with an agent. And in our case, it was a good friend of his, a golfing buddy, who convinced him that he should replace his existing VUL policy with an equity index product, which is a common occurrence that we see these days. Because of the difference in the rate of return in the policies and the fact that what he showed his client was a new policy with a lesser death benefit, as the death benefit need had dropped for this particular grantor, again, something we're seeing a lot of these days, the agent showed an illustration that seemed to be of a policy that was less costly because it had less death benefit. So it had less premium need because of the lesser death benefit, but it was not less costly. In fact, when we reviewed the policies at the same death benefit, we found that the new policy, the one his friend wanted the trust to buy, had costs within the policy that were 4 times what the existing policy's costs were. And this was because of changes in health and the underwriting that had occurred in the insureds. The cost of insurance inside the new policy was higher than the old one because the insured's health had changed for the worse. The agent even wanted his client to fire the trustee because the trustee turned down the replacement because of our review. And you have to know about the options in the existing policy, not just look to another policy without understanding what can be done with the old policy. We had a case where an agent wanted to replace 3 whole life policies with a universal life policy. And the grantor seemed to think that this all made a lot of sense. Again, it was a situation where the death benefit was going to be reduced in the new policy, but in this case, we found that simply reducing the existing policy's death benefit would actually provide us with a far superior outcome, one that was never reviewed by the agent or the trustee. In fact, we found that we could provide $500,000 more in coverage guaranteed to maturity by just reducing the death benefit. And we'll see in a minute how in the Cochran case, the trustee was found to have made a prudent decision. But in the 2 cases I pointed out here, if an attorney could show you that you had accepted a replacement policy that cost 4 times as much, or a policy that provided $500,000 less death benefit for the same cost, how do you think that you might fare in court? And remember, these were just cases we ran across, and we might be a pretty big company and we see a lot of replacements, but we do not see all of the replacements in the industry, or even a majority of the replacements in the TOLI industry, not by a long shot. So how many TOLI replacements out there have gone through that were really not prudent? Cases like these 2, where you could literally show a court of law that the replacement actually damaged the trust and the beneficiaries. So I can show you these situations where we may have come across replacements that could have created true liability for a trustee, But in the Concord case, not so much. The court found that even though the bank only looked at one policy with one company and could have certainly done more, in this case, it was enough, according to them. Again, many pundits believe a low bar was set with this case, and I would suggest that any time that a policy is purchased, whether it's a replacement policy or an initial policy, you do more investigating than this. But though the court found the process less than perfect, they believe that it was adequate. While the beneficiaries charged that the bank breached its duties by failing to provide sufficient information regarding its plan to carry out the 2003 exchange, the court disagreed. And one reason was that the trust document gave the trustee the power to surrender or replace the policies without the consent or approval of anyone. So according to the court's findings, the trustee had no duty to notify the beneficiaries of the replacement or get their consent or approval. Again, to me, it's a low bar, and I've always argued that if the discussion around the replacement had been more robust and had included the beneficiaries, then maybe there would not have been a court case. And again, that's the goal. We don't want to win in court. We don't want to be in court. So today, with issues like non-performing policy, cost of insurance increases, there's a real need to monitor policies, and I'm sure all of us would agree. And keeping the grantor abreast of this is something that is important. What we found is that issues tend to creep up slowly in policies, making the grantor aware that an issue might be coming makes it that much easier to explain the issue when it actually arrives. So obviously, we're big believers in annual reviews and reports going to the grantor. And when there are issues, even if the issue is way down the road, we're big believers in explaining the issues and the options as soon as possible. The question is, when do you reach out to the beneficiaries? I think it's always a plus to get them involved in the trust whenever you can. And I know that many of you that are on the call would like to have the beneficiaries as clients. After all, that's one of the reasons why you have these ILETs, is that when the grantors pass, that the beneficiaries will be your clients. And what better way to increase that chance than by showing them how well you handle this asset that you have, which one day is going to go to them. But you must reach out to the beneficiary if the asset in the trust is going to change, when the performance affects the benefit, or like in this case, when a replacement or a change in the policy is going to lower the benefit that the beneficiaries will receive. The beneficiaries also claim that the bank breached its duty of loyalty to them through contact with the grantor concerning the policies and the policy replacement. And they believe this was evidence that the bank was loyal to the grantor and not to them, the beneficiaries. And this is an interesting situation because during any policy replacement, the grantor is going to be part of that process. And the court really saw it that way, and they disagreed with the beneficiaries again. And I think they rightly said that the trustee would have to have discussions with the grantor insured if changes were going to be made to the policy, because there are physical exams and parameds, et cetera, that are going to take place. Now, in reality, most trustees, you know that the agent's going to be handling that, but I still think the court was right in saying that the underwriting process really cannot take place without some communication between the trustee and the grantor insured. So it's not an issue when you have a grantor replacing a policy or getting a policy that there's this conversation occurring. And the court said there's no law that would prohibit contact between a trustee and a grantor, and there shouldn't be. But again, you have to keep in mind that the grantor can't have undue influence over you. So I think that even though the outcome of this case was very favorable to the bank, in the spirit of staying out of trouble, out of court, I want to point out some items. First of all, The former trustee relinquished the trust at least partly because of the grantor's noodling in trust decisions and bringing in outside parties. And personally, I would have voted against bringing in this trust if I had a vote. But once the trust is in, you have to make sure that the grantors do not feel they have the right to influence you. And even though the court said that the replacement made sense, and I don't disagree necessarily, there is a case to be made here that with the rapid changes in policy type within this trust, there's a kind of flavor of the month mentality that you could make a case for. And these transactions are often very costly, and in this particular situation, there was over $100,000 in surrender charges lost in the VUL replacement alone. If you do not understand the replacement, either all of the options on the existing policy or what the new policy is, you need to find out. And we see a lot of liability in this area, and that's why I wanted to bring this up. A lot of trustees not understanding fully the transaction. And we had a prospect contact us a month or so ago because he had written a large 5-figure check for a 2-year-old replacement that was found out after the fact that the replacement was not really prudent. And by that time, there was nothing anyone could do except to make the client whole and therefore write a check. And you're never going to hear about these cases, but they are out there. As always, document all of the decisions and all of the policy options and why you made those decisions, and make sure all of the pertinent people, especially the beneficiaries, are made aware if there's any changes to the trust benefit, and make sure that all of that awareness is documented in your file. The second case we're going to review is the French versus Wachovia case, which also grew out of a replacement case, but this one was an internal replacement, meaning that the affiliated insurance agency of the bank was the one who generated the commission on this particular case, and it was a very, very large commission that kind of played into the case development. The grantor was a successful businessman who approached Wachovia about 2 whole life policies that he felt weren't performing. And he had grown disillusioned with his former trustee. And he met with insurance advisors at Wachovia who developed a proposal to exchange the 2 whole life policies for, again, John Hancock guaranteed universal life policies. The grantor received a memo that outlined the pros and cons of the transaction. For example, the new policies were guaranteed, but premium flexibility would be lost because these were guaranteed universal products that needed a set premium to be paid. And the cash value in these policies would be much less, since by design, a guaranteed universal life policy does not generate much cash value. After he signed the application for the new policy, the grantor was asked by Wachovia to sign a waiver that disclosed that the bank would receive compensation and included a broad release of claims arising out of their purchase of the insurance on behalf of the trust. The grantor inquired about the possibility of rebating the commission, and after being told that that was not allowed under law, he refused to sign the conflicts waiver. The bank withdrew the request for a signature and then moved ahead with the replacement. Afterwards, the grantor and the beneficiaries complained to Wachovia and then retained a law firm and tried to reverse the transaction. Since that could not be done, the children who were the beneficiaries wound up suing Wachovia. The beneficiaries claimed that the insurance replacement violated the prudent investor rule. And if it didn't do that, the bank at least made the insurance swap in bad faith. They also said the replacement was such a bad investment that it amounted to a violation of the bank's duty of prudence. The case really started because the grantor and the beneficiaries were upset that the bank's insurance affiliate made such a large commission on the transaction, and it was a large number. It was over $500,000 that was paid in commissions, but as you'll see, the court did not hold that against the bank. The court did say the trustee has a duty of undivided loyalty to the beneficiaries, and that included in that duty of loyalty is the strict prohibition against self-dealing. However, the court pointed out that in fact the trust document can actually waive that requirement and actually can allow the trustee to engage in transactions that involve self-dealing. And in this particular case, there actually was an express conflicts waiver in the trust document that allowed the trustee to operate without regard to conflicts of interest. Now, we're going to see later where a trust clause did not help the trustee, so it's important to note that the court also felt the bank handled this particular situation prudently and responsibly, in addition to having the trust language on its side. Though the beneficiaries characterized the replacement as a bad investment, the court saw it differently. In fact, the transaction provided the trust with the same death benefit, but at a reduced cost, and actually saved the trust $620,000 in premium over the existing policy. Now, it is true that the new policies did not have the high cash values that the whole life policies had, but the bank's insurance advisors made that clear to all involved in their memos and their meetings, and just as important, the advisors understood that the trust had other assets, and it was well diversified with these other assets. So this was an important part of this case, as the trustee showed an understanding of the trust and its needs. The trust had other assets, other cash, so cash value wasn't that important. So saving money was more important because the trust, excuse me, had these additional assets if cash was needed. In this particular case, the court found in favor of the bank and awarded the bank over $700,000 in attorney fees. So this is a case to be aware of, especially if you have an insurance affiliate that might receive compensation from a transaction occurring within the trust. Certainly you need to understand the trust document when bringing in a trust. In this case, the document language allowed self-dealing and was specific in the language. While the trust language helped, the bank did show it acted in good faith, and this was a key. It showed a rigorous review with numerous meetings with the clients, and they had life insurance professionals who put together significant documentation and outlined the advantages and the disadvantages of both the existing and the replacement policy. So when deciding on a policy replacement, the policy characteristics and performance are considered, but there's also other factors you need to take into consideration. And in this case, the bank did that. Because of the other assets, the decision to purchase a more efficient death benefit at the expense of cash value was deemed to be prudent. The last key here is the documentation by the bank on its review procedure, which was the key really to offsetting the bad taste left by the large commissions paid on the case, which were actually standard, but it seemed out of line to the parties to the trust. So the fact that the bank could show how much work went into the analysis with the memos and the meetings with the grantors and the beneficiary and the advisors, this showed that the bank had satisfied its duty to show good faith and make a prudent decision while earning a large fee. The next case, Hatleberg versus Norwest Bank, is focused on a poorly written trust document and the trustee's responsibilities to alert the grantor once made aware of the issues around the trust. The backstory is, after prompting from a bank official, a client of the bank set up an ILET, and she used a neighbor, a local attorney, who actually admitted he was not an expert in estate planning, and copied the trust document from a form book. The document did not contain crummy provisions, which is obviously an error on his part. This was not initially noticed until the bank performed an annual review, and even after the bank and the attorney who created the document knew about this issue, they did not alert the grantor. In fact, nobody was made aware until after the grantor died, when the bank notified the probate attorney. Now, the positive outcome for the trustees on this webinar was that the court found that you have no duty to review trust documents to make sure that it is effective as an instrument to avoid estate taxes, since the document did not assign you this responsibility and you were not responsible for the trust document. So this was a good thing for you as a TOLI trustee. But unfortunately, the court did agree that the trustee actually breached a duty to the grantor by continuing to direct her to contribute to the trust with the idea that she would save estate taxes even after the trustee realized that the trust was defective. In this case, the court found that the trustee and the attorney were financially liable for the additional estate taxes due. The key lessons from this case, well, it's clear that you might not be responsible for defects in the trust document that you have nothing to do with, but once you are aware of them, you need to make all parties aware of it. You do hold the responsibility and can be held for potential damage. And this case also points out the need for proper administration of the crummy provision. But I think the clear message is that you're transparent with the parties to the trust when issues arise. Even if they're not caused by you, keeping them to yourself will cost you. And this is consistent whether the issue is a legal issue or a policy issue. Once you are aware of the issue, you need to make all parties aware. A fourth case is Paradee versus Paradee, and it was a 2010 case. And the first thing that jumps out at you when you look at this case is the fact that when you have a dysfunctional family, you have a recipe for complete disaster. And I've often said that most of the TOLI issues are people, not policy issues, and this was definitely the case here. Here's the backstory. The trustee and a non-fiduciary family member were found liable in the case. And here are the facts. Charles Sr., the father, set up a life insurance trust for the benefit of his grandson, Trey. Trey's dad, Charles Jr., was estranged from his father. The policy insured Charles Sr. and his second wife, Eleanor. Charles Jr., the son, was part of the family business, but the business was cut up with a portion of it run by Charles Jr. as a separate entity. And the son felt his father's second wife turned his father against him. He felt slighted by his father, and his father felt betrayed. So you can see how this is setting up to be a mess just by the beginning of the case. The agent who sold the policy was the initial trustee, and he had done a lot of business with both the father and the family firm. And the grantor, Charles Sr., had physical and mental health issues, and Eleanor, who was the second wife, appeared to be taking over the financial aspects of the family. She asked the trustee at various times to revoke the trust or surrender the policy, and then asked to get a loan on the policy, which actually was done and under very favorable conditions to Eleanor. When Charles Sr. passed away, the trust had the right to recover the principal and interest due, but the trustee, who was also the agent, never tried to. Trey, soon after turning 30, Trey soon turned 30, and at that point, he was supposed to be allowed to be trustee, but he was never told. And eventually, Eleanor appointed herself trustee of the trust. Interest was not paid on the policy after Eleanor made herself trustee, and the policy lapsed. Then Eleanor resigned and appointed a family handyman as trustee. It can't get much better than this. The handyman actually turned out to be the best trustee of the three, and he let Trey know of his rights, and Trey demanded the loan to be repaid, and it was paid back. But a lawsuit ensued, and the court declared that the original trustee, the agent who sold the policy, breached his fiduciary duty, helped by Eleanor. The key statement was that the trustee was under a duty to the trust beneficiary to administer trust property solely in the interest of the beneficiary. But during his tenure, he did not evaluate what was in the best interest of the trust. He evaluated whether he could please his longtime clients. Eleanor was found to be part of the problem, and the court found her liable since the conduct of one who knowingly joins with a fiduciary in breaching a fiduciary obligation is equally culpable. She was held liable for over $1 million, with additional awards shared by Eleanor and the trustee. So, the first critical point here is that you, as a professional trustee, are held to a higher standard than the non-corporate trustee in this case. And we've talked about this already, about the grantor of a life insurance trust often having more profitable business dealings with the trustee than the ILIT is, but that can't sway you as the trustee from following the duties to work in the interest of the beneficiary. When the grantor request cannot damage the assets of the, when the grantor request cannot damage the assets of the trust, or the trustee could be held liable. The other item here, and this is important, and I have found after a decade of working with TOLI cases that family squabbles, second marriages, failing physical or mental health of the grantor, these are all red flags that signal that a trust requires special diligence, and they're all red flags that require that you provide additional diligence to the trust, or else your liability will be raised. Our fifth and second to last case is probably the most confusing case we'll look at today. It's confusing as to why it happened and what actually happened in parts of it. A grantor had her attorney draft an irrevocable life insurance trust that contained 3 policies totaling $8.5 million in death benefit. The attorney named himself trustee. Article 2 of the trust instrument he drafted stated that the trustee had no duty to pay the insurance premiums, notify the beneficiaries of non-payment, and no liability if payment was not made. The attorney, who was trustee, when filling out the policy applications, for some reason provided a false address in South Dakota. Nobody that I could find knows why this was. There were $250,000 in premiums paid to start the policies, but all of the notices, the premium notices and then the lapse notices, were sent to this false address. There was another $250,000 in premiums that were paid to the agent of record, but he did not forward it to the carrier. And according to the court documents, the beneficiaries, quote unquote, did not know what happened to the premiums. So, the trustee cited the exculpatory language in Article 2 as his defense, but the court was not going to go along with this. They cited common law rules and said that the authority of a trustee is governed not only by the trust instrument, but also by statutes and common law rules, and they found that the trustee's defense was untenable because it challenged the most basic understanding of a trustee's duty to act for the benefit of the beneficiaries under the trust, which is the most fundamental duty. And the most fundamental duty is the protection of that trust property. The trust language could not help the trustee since he did not act in good faith. And this is the key here. While in the Wachovia case, the exculpatory language helped, in this case, it could not nullify the trustee's duty to act in good faith. and in accordance with the terms and purposes of the trust. So even though this document stated that the trustee would not be held liable, he actually was, because he did not act in good faith. So what are the key lessons in this case? Well, the first one is common sense. I mean, when you look at the facts of this case, it's unbelievable that this actually occurred. So there's actually no step in this process that you can say that the average person with reasonable common sense, whether they were, never knew about being a TOLI trustee or a trustee at all, they wouldn't have allowed this. It just wouldn't have happened. We saw that in the Wachovia case, how the trust language could alter or waive responsibilities, but you have to follow fundamental duties in order to have that happen. The exculpatory language alone is not going to protect you. It just can't when you are doing something that makes no sense at all. The other thing you have to take away from this, and this is something that's just good administration, make sure you review every application to verify the information, especially the contact information. And when the policy and the trust comes in, make sure you contact the carrier and make sure that they have the correct information or the same information that you have, and that the address is your address as trustee of record. And never, ever, ever provide a premium check not made out to the carrier. Never give a check to someone to send to the carrier. Always send the check directly to the carrier yourself. Now, the last case we're going to go through, the Nacchio versus AYCO case, this is not a TOLI case, but it's one that has to be on your radar, because all agreed that the defendants in the case were in fact fiduciaries, and the settlement awarded to the plaintiffs was very large. The backstory on this case: Joseph Nacchio was an executive, and David Weinstein was his advisor at AYCO, which is a subsidiary of Goldman Sachs. And they developed this executive compensation plan that utilized life insurance. According to the plaintiffs, the advisor, Weinstein, encouraged his client to take part in the program, and they purchased 2 survivorship variable life policies with $95 million of death benefit, paid for with a single premium of $4.5 million, that, assuming a return of 10.68 and 10.8, would have carried the policies out to age 100. 10 years later, the policies were evaluated. It was found they were not performing as expected, and Mr. Nacchio ceased participating in the plan, which cost him about $2 million in fees and taxes. He then went out and purchased $85 million in life insurance coverage for $27 million. And this coverage had to be on single life because the policy was on his wife, because Mr. Nacchio, in the interim, had gone to prison for insider trading in a trial that his advisor had testified at. Again, as I said before, many of these cases have very, very sticky backstories. So Mr. Nacchio and his wife filed suit in 2010 while he was still in prison, and they alleged their advisor breached his duty of care. The plaintiffs had a life insurance expert testify that Mr. Weinstein was a fiduciary under the Investment Advisors Act of 1940, and that based on his analysis, the policies had a less than 25% chance of being successful. In other words, he had a Monte Carlo analysis that the policies had a 75% chance of failing. They would not make it to age 100 as was expected, as the client thought they would. The lawsuit alleged that Mr. Weinstein was negligent and did not provide an expected level of care. The defendants had their own expert who testified that the program identified the risk of the plan and the fact that additional premium might be needed, a point that the attorneys amplified during the trial. And they mentioned that not only were Mr. Nacchio and this expert informed of the issues, but their estate planning attorney was made aware of the fact also. So, question to the audience: would you have allowed a grantor in your trust to assume that they could get a 10.6 plus return on a VUL policy? And this is where it gets kind of sticky. In this case, we had an expert who said, according to his Monte Carlo simulation, the chances of success for these policies was about 25%. There was a 25% they would reach their goal. But the defense pointed out that, through their witness, that in 2000, when the policies were taken out, a 10.6 to even 12% return was not completely uncommon. And the defense's expert said that the use of Monte Carlo simulation that the plaintiff's expert espoused was not only not best practices, but in his words, it would have, quote unquote, directly violated NASD rules. Variable policies are under NASD because they're a security. Now, I know of both of these experts. I don't know them personally, but I'm just pointing out that here's a situation. You get two sides to a story, but the question is, which side is going to win out? Well, in this case, it took only 75 minutes for the jury to award Mr. Nacchio $14.2 million, which was the amount that would have been needed to purchase the coverage they thought they were getting in the year 2000. Pretty big number. Now, this was not a TOLI case, but there are key lessons here because they were deemed to be a fiduciary. And the first one is, when bringing in a policy, you need to disclose and document the expectations around the policy. What is it that's expected of this policy? And you need to make sure those expectations are reasonable, and then the actual policy performance is monitored with documentation, and all pertinent parties are made aware of that documentation. In this case, it was shown that the advisor actually did meet with the plaintiffs because this advisor was his financial advisor. And yet, in this case, they were awarded $14.2 million. So, some final thoughts. We've gone through a number of cases today, and I hope that you got some good information and good ideas on how you should and should not proceed. There's some final thoughts here. Opinions are just that. In other words, each of these court opinions are just the opinions of that court. Maybe they get overturned. Maybe if it had been another court, it would have been another opinion. The other thing that you need to realize is that things change over time. Attitudes change. Right now we're seeing a lot of litigation in the 401k arena, where firms are being sued because of the costs within their 401ks. That was something we would have not seen or thought we would see 10 or 15 years ago. How are things going to change in the next 10 to 15 years when it comes to TOLI? Next, the goal is not to win in court, it is to stay out of court. So when we talk about these cases, you have to look at what you're doing and apply these cases to your day-to-day activities and be very prudent in your actions to make sure that what you're doing is not going to allow someone to put you in court. Prudent TOLI and policy management is dependent on a good process. Without a good process in place, you simply are not going to be able to manage these assets prudently. One of my last thoughts on this goes back to the UPIA Section 8, and I think this is incredibly important. It says compliance with the prudent investor rule is determined in light of the facts and circumstances existing at the time of a trustee's decision or action and not by hindsight. In other words, if you make a decision today and you base that decision on good facts today and it's a prudent decision today, then according to the Uniform Prudent Investor Act, you cannot be held liable for something that might go wrong down the road. And this is very, very important. And the most important part about this is you have to prove your compliance with that Section 8. You have to prove that what you did today was a prudent decision. You need to have that in your trust documents. You need to have that in your trust file. And how do you prove your compliance? It's documentation. So one of the things you should take away from this as you read over the chapter or think about what you've learned today is how can you implement into your documentation on a day-to-day basis the things that we've learned today that got other people in trouble. How can you by your documentation, make sure that you don't find yourself in the same situation as these trustees did down the road. So I appreciate everybody taking part today. If there's any questions that you have, you can type them in, and I'd be glad to answer them. Are there any questions that anyone out there has? I see there might be a question coming in, so let's wait a second. Question, when evaluating TOLI as a trustee, how much you rely on the in-force illustrations provided? Most illustrations show current and guaranteed rate, but it seems more often not that these illustrations are very accurate, and the insured ends up facing a bad decision to cough up more money to keep the policy from lapsing prematurely. That's a great question. How much do we rely on illustrations? Well, I would like to say that we rely on them too much, and we rely on them not at all. And what do I mean by that? I mean, we rely on them because they're numbers, and this is the way I explain it to people. If I said to you, you want to have $1 million at retirement, and we're going to say you're going to make an 8% return and put in $5,000 a year, are you going to wait until you're 65 years old to find out if you had $1 million? No. And that's the problem with illustrations. Number one, life insurance illustrations, permanent illustrations, show a consistent level, crediting rate, rate of return, dividend, whatever the cash value is invested in over the life of the policy. And this is something that is impossible. Those numbers in the illustration will not come true. So that's the first thing you have to realize about illustrations. The second thing is, an illustration can be played with. And so if you don't understand how illustrations work, if you don't understand the cost of insurance behind a policy, then you can get into a lot of trouble just dealing with illustrations. The case I talked about back there, where it was a VUL policy to an index UL policy, the agent manipulated the illustration by showing a rate of return in the index policy he could not get, and because he lowered the death benefit, he showed a lower premium for that particular situation. That lower premium was not a lower cost policy. So equating premium to cost is the first mistake people make when they rely on illustrations. Unfortunately, there are a few things that provide us a numerical explanation of the policy. So we rely on illustrations, but we do because we're professionals and understand how to look at them with a grain of salt and understand what's behind the illustrations. Our team in New York City can tell you to the penny what your cost of insurance is in a policy on a monthly basis, and that gives us a leg up over many people. So long story short, you really can't rely on illustrations to provide you with more than just a guideline. And I think Chad is sending me these questions. That's why it's taking longer. Any more questions, Chad?
No,
Okay.
no other questions have come in.
Okay. I appreciate everybody taking part in our session today, and I look forward to next month when our IT team and Corey are going to be presenting on artificial intelligence. It's a little different subject matter for ITM 21st University, but it's a session I'm really looking forward to. Again, I appreciate everyone taking part today. If anybody has a question and want to reach out to me individually, mbrohan at itm21st.com. I'd be glad to hear from you after this session or going forward. Again, everybody, thanks for taking part today.